All right, welcome to Employment Law Show. Once again, John Scholes, Lior Samfiru, right beside me. Welcome to the show. Lots of employment law knowledge about to be thrown at you, so take it all in on the show today. What you need to know about terminations. I'll give you some contact off the top as well. 1-855-821-5900. help@employmentlawyer.ca is the email address, which we will refer to several times on the show today. And right off the top, a wonderful website for you, absolutely free and anonymous, full of information, pocketemploymentlawyer.ca. Again, we're going to refer to that throughout the hour, so stick around for that. Brother, lots to get through on the show today. We're going to get some phone calls from our live radio show as well. It's been on the air for 9 years plus. I think we've been doing that a long time. We take some of the great phone calls from it and play them back here and talk about them. That is just ahead, though. But first, the week that was. What's going on in your world?
Hey, John, great to be back with you, physically distancing, but still back here to talk about employment law and workplace rights, and hopefully help shed some light on this topic that has impacted so many of us over the past year or so. So this is really about you, about what you need to know about this very important topic, which is your workplace rights, your employment law entitlements. If you're out of work, off work, laid off, job has changed, compensation has changed, not being called back, mistreated, harassed, discriminated, you name it, we cover it on this show. And the reason we do this is because in my office, I get questions like that all the time. So we thought, hey, what a better way to reach people than to do this show right here so that we can talk to you about what you need to know. We'll cover a lot of topics on this show like we do every week. But if we don't cover your specific situation, we don't answer your specific question, not a problem. Reach out to me off air. We'll get you that contact information throughout the show so that we can connect, we can have a discussion, we can hopefully solve your problem specifically. So don't be bashful. Now, that out of the way, let's talk about a situation that came across my desk. Now, I spoke with a gentleman. He had been watching the show regularly, and he had heard me say on the show that regardless of why your employer put you on a temporary layoff, COVID-19 or not, that is a termination. That is something you can treat as a termination. So he decided he wants to treat it as a termination and get his severance. He contacted his employer and he said, employer, I want my severance. His employer wrote him back, sent him an email saying, you're confused. We did not let you go. We're planning maybe at some point to bring you back to work, hopefully in a few months or so. You're off because of COVID-19. The government allows us to do this, so it's not a termination. So getting that response from his employer, he contacted me and he said, well, Lior, you're saying one thing, my employer is saying a different thing. Which one or who's right? So I wanted to bring this up here because we need to clarify this. If you're on a layoff because of COVID-19, or it doesn't have to be because of COVID-19, but a lot of people are because of COVID-19, that is still a termination for most people, full stop. You have a right, if you want, to treat that as a termination and get your severance. You don't have to wait. You don't have to see what happens. You don't have to get your employer's permission in that respect. You can make that decision. Now, your employer itself may not be aware of this. Your employer may not understand that layoff they put you, that they thought they were allowed to put you on, is in fact illegal, that it is in fact a termination. So if you're in that situation and if you don't want to wait, you don't want to be in this gray area, in this no man's land where you're waiting, don't know what happens or what's going to go on, you can get your severance right now. That is fact. That is the law. If you want your severance, let's talk about it. Remember, if you accept that layoff and go back to work, you've given the company the right to do it again and again and again. So certainly something to consider. If you want your severance, let's talk.
Rather than giving up that right away, can they maybe draft something to the employer saying, I understand under the circumstances of the pandemic and we're working from home, maybe you've laid me off for whatever reason. I'll allow you to do it this one time, but I don't want this to be an implied term of my employment moving forward. Therefore, you can't do it again. Can they do that? Is that possible?
They could potentially do that when called back to work. To say, just so you know, employer, by coming back to work, I'm not agreeing to future layoffs. I'm doing this only in this unique situation. But the reality is the employer would have to agree to that. So it may not be that effective. It's better than just going back to work and saying nothing. But you are still taking a risk in that situation that you may be considered to have accepted the layoff despite what you said, despite what you intended. The safest way to preserve your rights is to treat that as a termination and get your severance and hopefully move on to somewhere better.
The website, again, employmentlawyer.ca, is good for many things, including finding a radio show, our long-running radio show that's near you, where you can catch it within earshot. We'll go to the radio show now, Lior, the one that we do every week for an hour. Get a ton of phone calls on the show. People have questions like you would watching this TV show now. And we'll play it back now. We'll get some comments on it. So phone call number one for today's show is right here.
I'm their VP of Finance, have been there for 21 years. The company was acquired 4 years ago by a U.S. company, and they at that time signed me on to a new contract that was same pay. They want to severance me out, 12 months severance.
So this is an interesting situation. This is something that I actually see happen quite often. Let's say you sign a contract for a specific period of time, 6 months, 12 months, 3 years, like this person, whatever that is, a specific period of time contract. If that contract ends, that end date of the contract comes and goes, and you continue working for the company, then now obviously the contract is dead. It's gone. It doesn't exist anymore. Now you're employed under an oral agreement. So that could be a very good thing, because there could be terms in that agreement, the one that expired, that limit your entitlements. And once it expires, you have nothing limiting your entitlements. So in this particular situation, his employment gets terminated now. He's no longer under contract. That contract is gone. So the fact that he's limited to 12 months of severance in that contract is irrelevant. So how much severance does he actually get? Well, let's go to pocketemploymentlawyer.ca. Let's plug his information in there and assess how much he's owed. So he said he's in a senior executive role. He's been there now 21 years. We know that under that contract that doesn't exist, it said 12 months, but you can see right at the bottom of your screen there, what he's actually owed, his actual severance entitlement is 24 months pay, double. That's why actually, if you have a fixed term contract and that contract expires, it's actually a good thing. You don't want to knock on the company's door and say, oh, company, my contract is ending, let's sign a new one. You want to continue working without having a contract. That's the best case scenario. You know, it's always frustrating for me when I hear employees asking for a written contract. Remember, for an employee, you're better off without a contract. And oftentimes what a written contract does is limit or tries to limit your future severance. For this person, the fact that he doesn't have such a contract means he gets 24 months severance instead of 12.
And it doesn't matter if he's working for a U.S. company, it still applies to whatever Canadian laws or provincial laws you're under, right? Not U.S. law. People think that, right?
If you're working in this country, Ontario, Quebec, BC, Alberta, wherever you are, it's the laws of those provinces that apply to you. Doesn't matter what your contract says, frankly, doesn't matter what the contract, where the company is based out of. If you work in Ontario, for example, it's Ontario laws, and that is a very good thing. You want Canadian laws to apply to you. You do not want U.S. laws. They have employment laws that are very different, not as good or favorable. So yes, Canadian laws is where it's at.
I mentioned terminationquestions.com, Lior, at the start of the show, and for you as well. Anytime you want to use that website to ask some questions. I want to get to one now, and I know you want to answer this one from Craig. First one says, can my employer reduce my salary because I moved out of the city? The company shifted everybody to remote work due to the pandemic, and we are expected to remain that way even after COVID-19.
You know, I've been getting questions like that, John, quite often now, with so many people are working remotely. So let's clarify that. If you've moved out but you're still in the same province, as long as you can do your job, your employer cannot tell you where to live. Your employer cannot punish you if you've moved, and that's something that, frankly, it's none of your employer's business. Now, you do have to consider what happens if you do have to go to the office. If you live too far, are you going to be able to go back? Because your employer can say at some point, hey, now COVID-19 is over, maybe, we can have you go back to work. But as long as you're working remotely and you can do your job, you can't be told where to live so long as you're in the same province. If you're moving out of province and thinking, well, it doesn't matter, I'm working remotely, so does it matter if I live in Alberta or BC? Well, yeah, it does matter, because every province has different laws, and your employer may not be able to have employees in a different province. So moving out of the province while working remotely is a problem. Within the province, you can do whatever you want, and your employer cannot do anything to you or tell you where to live so long, again, as you're able to do your job properly.
All right, good, strong opening start. We got to take a short break, Lior, so stand by for that. In the meantime, you want that phone number to reach out to Lior and his team, 1-855-821-5900. help@employmentlawyer.ca is the email address. And we've already gone to it once, pocketemploymentlawyer.ca as well. We'll continue. Stand by. Employment Law Show continues. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back. Employment Law Show, reaching out, simple, 1-855-821-5900 anytime to get a hold of Lior or a member of his team. help@employmentlawyer.ca is the email address, which we'll refer to in just a little while. But as mentioned, Lior, I want to get to this. What you need to know about terminations. It is an endless list, but I think we got it down to about 5 or 6 talking points. So we'll start with the broad one. Are there different types of terminations?
Termination, John, very important topic. A lot of people have learned about that or have found out the hard way, having lost their jobs recently over the last few months because of COVID-19. But despite the fact that it is certainly a traumatic event, and it's an event that no one will ever choose for themselves, of course, you have a lot of rights here. Employment laws provide significant entitlements on termination, usually in the form of compensation or severance that you're owed. So we want to talk about some of these concepts so that you know how to deal with your termination, so that you know what your rights are if you face that unfortunate event. So first of all, types of terminations. There's generally 2 types of termination. The first termination is what we call a termination for cause. A termination for cause can only happen if an employee is guilty of very significant misconduct, if that misconduct is repeated, and if the company essentially has done everything they can to fix that problem, but they failed. So at some point, the company is going to put up its hands and say, what more can we do with this bad employee? We're going to let them go for cause. Remember, it is very, very difficult to establish cause because it's reserved for the worst offenders. And the fact that you may have done something wrong, or even a few things wrong, does not mean that that's cause. Cause is a very high standard. If the company can establish cause, that means they can let the employee go with no severance. Very difficult to do, and a lot of companies try to do that before they should. The other type of termination is a termination without cause. So generally, anything that's not a termination for cause is a termination without cause. A termination without cause can happen for many reasons. It could be a cost cutting. It could be restructuring. It could be a company shutting down. It could even be a situation where the company is not happy with someone's performance, but they know it's not bad enough to be cause. If they still want to part ways with the employee, they have to treat that as a termination without cause. And of course, in a termination without cause, the employer has to pay full severance. So either you've been terminated for cause because you did something horrible, something awful, or you've been terminated without cause, where the reason doesn't really matter or factor in. But in that situation, John, you're owed your full severance.
You know, the terms notice of termination or working notice, when an employer throws that at you, what does that mean?
So generally speaking, as we've said, an employer has to pay compensation to an employee when the employee is let go without cause, which is like 97% of all terminations. Now, when we talk about that compensation, the amount of compensation that the person is owed, there's a number of names that people use for it. I call it severance. Most people do. You can call it pay in lieu of notice. You can call it termination pay. It doesn't really matter, frankly. It's the amount of compensation you're owed if you lost your job. Now, one of the things an employer can do to maybe avoid paying that amount or maybe reduce it is by providing what we call working notice. So if someone is owed severance, and of course, severance is based on a few factors, age, position, and length of employment, the employer could provide the equivalent of that in advance notice. An example, let's say you're owed 12 months severance. Your employer could say, instead of paying you that severance, we're telling you today that 12 months from now, you don't have a job. So we're giving you 12 months notice of the termination of your employment. So long as the amount of notice is sufficient, the employer may not owe the employee anything else. Now, if the amount of notice is not sufficient, the employer is going to have to make up the difference at the end by paying severance. Remember, though, that is key here. That is the main message that I want you to take away from this segment, is that the vast majority of people, over 90% of people, when they are let go, are not provided enough severance, are not provided enough notice. That's what we call a wrongful dismissal. So you've been wrongfully dismissed if you're one of the 90+% of people that when you're let go are not paid proper severance.
Is it really a popular thing now, working notice? I mean, I guess if you have an employer who doesn't have deep pockets, it might be better than having to pay out a whole bunch of severance. I mean, you got to pay them anyway while they're working, but I mean, I can't see anybody on working notice for a year and a half. It would be bad blood inside the halls, right?
And exactly, it's for that reason that you don't see often a 1.5 year working notice. It does happen. It is rare. In most cases, the vast majority, when an employer lets an employee go, it's, today's your last day, pack up your stuff and go. In some situations, you may see very short notice, a couple of weeks, few weeks, maybe a month. In most cases, you will not see long notice, but it is legal, technically speaking, if that's what the employer wants to do.
Talking about the what you need to know about termination, some basics here, but they're okay. It's always good to review if you haven't watched the show before. And the next one is this: does the employer get to choose how much severance they give an ex-employee, or would they like to choose how much severance they give an ex-employee?
Well, I'm sure they'd like to choose, but I hope that our regular viewers know the answer to that, and that is an emphatic no. The employer doesn't get to decide. And by the way, I don't get to decide. The employee doesn't get to decide. The law makes that analysis and that assessment for us. The law decides how much severance you're owed, and that's the only thing that matters. Remember, the main factors, as I said earlier, are your age, your position, and the length of your employment. So the longer you work, the older you are, and the more senior a position you have, the more severance is owed to you. So that means that is what matters, not what your employer thinks. The net result of that is, as I said, that over 90% of the time, 9 out of 10 people, when they are let go, when they're staring at that severance letter, the amount offered there is significantly less than what they're actually owed, the real amount. 30% less, 50% less, 90% less. So that is wrong, that is illegal. So you have to get advice if you lost your job. Call me, email me, go to pocketemploymentlawyer.ca. You can calculate your own severance in seconds and know exactly what you're owed. Please don't accept it without getting that advice.
That severance offer, usually somewhere near the end, is going to have a deadline on it. Next Tuesday or Friday at 5. Does the employer have to abide by that deadline?
Well, if you think about it, John, your employer, large company, give you a letter with a very formal-looking deadline. We're offering you the severance, but here's a warning. You have to sign this by Friday or else. Well, most people, I think, will feel that pressure, that stress. Oh, my gosh, I have to sign this by Friday because, look, it says so. I'm not going to get anything. And I completely understand that. And because of that, so many people, unfortunately not knowing better, accept that inadequate severance, and then they realize it's too late to do something about it. So let's be very, very clear. That severance deadline is meaningless. It's nothing. It means it's not even worth the ink that it was used to write it. Your legal rights do not expire Friday, Tuesday, Friday of next week, whatever the deadline is. Your legal rights are what they are, what the law says that they are, and you have 2 years to pursue those legal rights. That severance deadline is a pressure tactic. Oftentimes, employers hope that the employee, feeling that pressure, will accept inadequate severance, and then that saves the employer a lot of money. Don't do that. Do not accept it. Doesn't matter how much pressure you feel. I get it. I'm here telling you, you will not lose your severance because the law has already decided how much you're owed, not your company.
What if it's a situation where an employee feels they're being pressured to resign, or there's been significant changes to the job, they don't like it? Do they just quit, or should they wait and get terminated?
Well, if you know that you're going to be let go, it's certainly better to let that happen than to just quit. And you know how many times I've spoken with people, well, I knew they were going to let me go Friday, so I beat them to it and I quit on Thursday.
Yeah, no.
Well, no, that's not a good thing. You're shaking your head, John, and absolutely, that's not what you should be doing, because by doing that, you could potentially be compromising your severance. They're going to let you go Friday. They have to pay you severance, which, by the way, could be as much as 24 months' pay, depending on those factors. So why avoid that? Why give them that gift by quitting? So no, if you're going to be let go, let that happen, and then let's make sure you get the severance that you're owed. But if something's happening that makes it difficult to continue working, the company's not letting you go, but you're being mistreated, your job has changed, you're being threatened, well, in that case, that could be a constructive dismissal. You could leave and still get your severance. The law would still consider that to be a termination. But best advice is this: do not quit. Do not say constructive dismissal. Do not make that decision without speaking to me first. It's absolutely fine to pursue constructive dismissal, but we want to do that correctly. We want to make sure that all our facts are put together before we actually go ahead and quit.
Again, employmentlawyer.ca, the website to find a radio show near you, which we do every week, have been for almost a decade now. So we'll get to another phone call, Lior, from the show.
I battle kidney stones and gout. I actually got the double whammy the other day. I ended up with gout in my feet and passing kidney stones at the same time. Went to the doctor, went to the hospital. I ended up getting a medical certificate from both places. When I turned them into my work itself, they rejected them, saying that the information on there was vague.
What information was on there?
That I was off work due to a medical incident and I had attended their offices. They've actually issued me a fine for attendance because of this.
John, I remember getting that call on the air when we were doing our live radio show, and I was shaking my head then as much as I am right now. Ridiculous, wrong, absolutely ludicrous. Your employer doesn't get to say if the note is good or not. If you have a serious medical condition, and certainly, unfortunately, this guy did, and because of that, you get a doctor's note saying you can't work, that is all that matters. A doctor saying you cannot work for medical reasons. Your employer doesn't get to know why, what the condition is, what treatment, why you were hospitalized. None of that is relevant. Either you have a medical condition that prevents you from working or you don't. And if the doctor says you do, that's all that matters. You can't be penalized. And can you imagine how ridiculous is it to penalize someone that's too sick to work? So what are you trying to, what behavior are you trying to correct? Next time, think before you get sick. It's ludicrous. So no, that's potentially a human rights violation we're talking about here. So if you're sick, get that doctor's note. Make sure that it's clear about your inability to work. Your employer cannot do anything for you. They can't ask for more information that's personal or private, and they certainly cannot discipline you or let you go because you are sick. That's illegal.
Let's take a short break, pal. We'll get to more, another phone call and maybe another email or two. You want to reach out in the meantime, 1-855-821-5900, help@employmentlawyer.ca. That's the email address. It's the Employment Law Show. Coming right back. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the Employment Lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the Employment Lawyer first at EmploymentLawyer.ca. All right, welcome back. Employment Law Show. John Scholes, Lior Samfiru. Third phone call from the radio show. Lior's coming up right now.
Hey, I'm actually calling for a friend. She worked for this company for a little over a year. They're downsizing. They no longer need her services. And because she was an independent contractor, she's not entitled to any severance. What's your take on that?
The old independent contractor.
Yeah.
You know what? We're laughing here. We're not laughing. We're almost frustrated because we see this often. On the show, I see it in my practice every day, multiple times a day, and that is individuals that are misclassified as contractors when they are truly and really employees. And remember, we talked before about the law deciding how much severance you're owed. Well, the law also is the one that decides if you're an employee or an independent contractor, right? You don't decide, I don't decide, the company doesn't decide. Doesn't matter what you sign, doesn't matter how you pay your taxes. What matters is, do you have a regular job or are you in business for yourself? If you have a regular job, you are an employee. It's as simple as that. So if this person has a regular job, the one that we just heard about, if she's going to work, if she comes back home and goes back the next day to do the same job, she is an employee. That means a lot of things. It means, of course, that she's owed overtime and vacation pay. But it also means now that she's been let go, that she's owed severance. Now, a lot of people may think, well, she's been there for a year. Okay, Lior, settle down. How much severance could she actually be owed after a year? Well, remember the rule. Short service employees, and certainly 1 year is considered short service, are treated disproportionately better when it comes to severance than long service employees. So let's plug her information in after 1 year of service into pocketemploymentlawyer.ca and see how much severance she's actually owed. So technical role, been there for a year. Wow. She hasn't been offered any severance because her employer says, oh, no, you're an independent contractor. What you see on the bottom of your screen there, if she truly is an employee in the eyes of the law, she's owed as much as 6 months pay, 6 months severance after only being there for a year. So that's what's at stake for her. Depending on her income, that could be $20,000, $30,000, $50,000, $70,000. So that's why it's so important, number one, to understand if you're an employee or an independent contractor, of course. And number two, regardless of whether you work somewhere for a few months or many years, you are owed severance. If either of those situations applies to you, you've been misclassified, you're looking at your severance letter, let's talk. You are likely owed a lot more than you realize.
Okay, a couple minutes left, and we're going to get this one in quickly. Or terminationquestions.com is where this comes from. Carla says, I was let go of the phone just a few weeks before returning to a project manager role after a 12-month maternity leave. My boss suggested via email before I took the leave that I might not have a job to return to due to the changes that my time off has forced on the department. Are they allowed to do that?
Absolutely not. And the fact that you and I have to sit here and talk about something that basic is frustrating. Right. Should be obvious. No, they cannot do that. You cannot be penalized essentially for taking a maternity leave. You cannot be penalized because you're off caring for your child in the first few months of their life. No. Your employer has to take you back to the same job, same compensation, with the same responsibilities that you had before you left. Even if it means they have to let someone else go, even if it means they have to work hard to make that happen, they have to do it. If they don't, it's potentially a human rights violation. It's a violation of employment standards legislation. It could be a constructive dismissal. You name it, it's wrong and it's illegal. So if you're ever in that situation, if your employer does anything to you other than take you back to your old job, coming back from a parental leave, that is wrong, illegal. You have to call me.
It's the old don't mess with mama. I've been calling it that, or dada, or whatever. Just don't do it, is basically what you're trying to say. We're done for another day, pal. Nicely done. Want to reach out to Lior anytime you can. 1-855-821-5900. Again, that was terminationquestions.com. But you have the option of email as well, help@employmentlawyer.ca. And the website, always use it, pocketemploymentlawyer.ca. It's a beauty. It's free and anonymous, and there is contact at the top right as well. We'll catch you again, the Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.